Actually, these are very new cases based on the Hague-Visby rules. There have been some changes of late, as the cases come up developing, there'll be certain interpretations on case laws that have come up connected to the Hague-Visby rules. Now, this is IM Bank PLC versus KCH Shipping, a very new case. The issue was misdelivery after the discharge. This has been a question actually connected to shipping. Is the ship liable? Is the carrier liable on it? That has been the issue, and these are the key issues. Now, normally the Hague and Visby rules are very clear on the carrier liability, not liable, that's what they say. But what if the delivery was not done? Let's say the discharge was from the ship done, but the misdelivery happens. And what about that 1 year time bar given? Because any legal action has to be done within that 1 year period, and exactly when that time begins. These have been issues in the Hague-Visby rule related cases. Now that's the law here. Article 3, what does it say? That the carrier and the ship shall be free from all liability unless action taken within 1 year. Remember, of the delivery or the time where the delivery should have been done. That's what the Article 3 says. So exempting the carrier liability. And then okay, even in any kind of a shipping deal, a contract is done. In this particular case, the contract clearly stated that the charter parties would come under the Hague-Visby rules. So that means this case was done, or rather this delivery of cargo was done under the Hague-Visby rules. And then the standard charter party bill, we call it the congention bill, that also clearly stated that the carrier shall, in no case be responsible. So the documentation, the law, the Hague-Visby clearly stated that the ship shall not be liable. But then, how did the case come up then? This is the story. Actually, the case connected to India, 85,500 metric tons of coal, and the bank has done the financing. The delivery was supposed to be done between 1st and 18th. It did not happen, and the thing was, it was delivered to another party thereafter. And it appears that the delivery was done to another party without having the bill of exchange at their hand. You need a bill of exchange to obtain goods from a ship, but this delivery has happened to another party without the bill of exchange at hand. So then the bank takes action against the ship, but they take more than 1 year to file up a case. So the defense by the ship was that, look, you did not complain within 1 year. So the argument here in the court is it fair enough for the bank to file legal action? Bank says they should be given the right because there was a breach of contract, because what should have been delivered to whom it should have been delivered has not happened. So the ship has broken the contract. So this 1 year bar should not apply. But when the case came into the Court of Appeal, the Court of Appeal was of the opinion that 1 year limitation counts, and that the contract was done under the Hague-Visby rules, the terms, the contract, the congention bill and all that. So therefore, what Hague-Visby clearly says, that any action, Rule 6, right, should be within 1 year, well, that should stand. So that's how the case ended. They're again justifying that the ship shall be exempt from all liabilities, even though in a situation where the delivery was not done, and definitely there was a wrong here where the delivery had been done to another party who did not have a bill of exchange. But the court was of the opinion of its stance, right, that any action within 1 year, legal actions are based on the practicalities. Even though the wrongs do happen, the time aspect plays a big role in highly crucial modes of transportation like shipping. So the courts being reluctant to extend that period more than 1 year is understandable. This one is again a problem that was unanswered related to Hague-Visby. What was it? Now, who has the duty of burden of proof with regard to the duty of care regarding the goods? Let's say there is a complaint about that the goods have not been taken care of properly during a carriage of goods by the sea. Who has the duty to prove the case of, the wrongdoing or the innocence? Is it the carrier who has to prove that they did nothing wrong, or is it the cargo owner who has a duty to prove that the carrier did the wrong thing? So this was a question in our laws, and the case is Wall Cafe Limited and another versus Compagnia Sudamericana, right, in 2018, a fairly recent case. And what did the decision was about? The carrier has the legal burden of proof that he took care of the goods, protect the goods from damage, and took proper care. And sometimes this care is related to the inherent issues, right, connected to the particular good, right? So inherent characteristics we call them. In this particular case, it was a case of absorption of moisture. Now that could happen in food item transportation. Imagine grain or rice transportation. So the nature, the element, the wind, the climate, the temperatures, the sea winds or whatever, right, can have an impact on the good. And these are the inherent characteristics. So there also the ship has a duty to prevent the damage from occurring. So the story is this: shipping, what was the good? The cargo, the coffee beans from South America to North Europe, rather long journey, and they were stuffed in unventilated containers by those employed at the dock, the stevedores crew. And these particular people were actually contracted by the carrier to take care of the goods, and they were lined with the craft papers, the picture of it here to show, against the moisture damage. But at the end of the journey there was condensation, the water, or rather water vapor, being contaminating the content. Then the owners of the good took action against the carrier, telling that there was not enough lining paper. You did not stand by the industry practice. But then the carrier argued, look, moisture is inevitable due to the characteristics of the cargo. And they said that there's no inherent wise exception could rely on. So inherent wise exception means things that would automatically happen. There's nothing that can do about it. Any transportation of cargo would face this challenge from nature, the natural aspects, which is there in the good no matter what. For example, take something like peanuts. Whatever the actions that we take with regard to the peanuts, the germs or the worms getting into peanut is there after a particular time frame or under certain conditions. So this is inherent wise in exception. That means would happen anyway, no matter whatever the care we take. So that was what the ship told. We took care, we took action, we put this particular craft paper, but we want to come under the security of the Article 4, Rule 2. But then what did the court say? The Supreme Court, this is UK. Carrier has the burden of proving that they did not break the Article 3, Rule 2 before seeking the defense under the inherent vice exception. So you have this Article 3, Rule 2. What is it? Carrier must prove either that they were not in breach of the Article 3, right? So that they took proper reasonable care of the goods. After proving that only, they can get the defense of Article 4 about the inherent vice exception. So the court was tough against the carrier actually. So this is what the Article 3 says. So carrier has a whole lot of duties, right? Fires, neglect, default, perils, dangers, quarantine restrictions. So for these things, Article 4, Rule 2 give loads of exceptions where these are inherent vices. But take a look at Article 3, Rule 2. Subject to the provisions of Article 4, that means based on Article 4's protection or the cover, the carrier shall properly and carefully load, handle, store, carry, keep, care for, and discharge the goods carried. So carrier must first prove, the Supreme Court stated, that they've followed Article 3, Rule 2 properly before they could even think about coming under inherent vice exception given under Article 4, where there's lots of protection given to a ship with regard to defects or the problems or the damages that could happen beyond their control, beyond the ship's control. But then the challenges. Now, goods are a complete different ball game, because if you take 100 different types of goods, 100 different different goods, the standards would be very different. It's not a common standard. So there may be, with regard to certain commodities, there are standards maintained, but so much of cargo that's been transported by ship has no standards agreed by the industry. So then what kind of a level of care is expected from a ship? Well, it's up to the court to determine on a case-by-case basis. So the best way is the carrier to be specific about the specific instructions that the shipper is asking for or giving, and then take that necessary care for the cargo. And of course, proper record keeping is a must, which is excellent. As a demand. So there the carrier's protection, the shipper's protection is guaranteed to a certain extent. Whereas Hague-Visby is very particular about protecting the carrier as much as possible, but not as much as the Hague rules. So this is one instance where the carrier liability could be an issue. Next, we move into this case, negligent navigation. In these modern days of extremely hyper quality, hypersensitive navigational tools and equipments, and the sat navigation, the GPS and all that, it's impossible to think of there could be a navigation error, but the likelihood is still there, albeit at a very small percentage. The case is Tasman Orient Line CV versus New Zealand China Clays Limited 2010. The case kind of came into end recently. So what does Hague-Visby Article 3 Rules 1 and 2 says? We know that, right? Carrier responsibility with regard to the goods. But then Article 4 Rule 2 says what? Carriers are not responsible for any act, neglect, default or of the master, as long as it's done in the navigation or in the management of the ship. but are generally only liable for acts directly within their control. So what does it say? So if the master happens to make up a mistake or error due to maybe carelessness, perhaps a failure to make certain readings or whatever, then the management of the ship is not liable. Regarding neglect, right, as well as an act, should it be within intention is a question. And then Article 5 says what? But deliberate act of a master or crew to cause harm to either the cargo or the owner of the vessel. That's about Act 5, I'm sorry. Now what? This is the case. So the master takes a shortcut through a narrow channel of Japan, because Japan is a long set of islands, the Honshu, Kyushu, Hokkaido, Okinawa. So there's this inland Japanese Sea and then the outer Pacific Ocean. So somehow, rather than following the proper route, the ship takes a shortcut as per captain's actions, the master's actions, and then there was a damage. The ship hit the bottom or rock or something, right? Starts taking water. But still the master did not stop the shop. He kept on moving the ship and didn't ask for salvage or any assistance. And what he did was he changed his idea of going through this short course, get back to the original way. That was his final action. Then what? By the time the salvage was done, the cargo was a total loss. It was, totally destroyed. And in addition, there were some other wrongs as well. Master, in a way, tried to destroy evidence or hide evidence that the ship had grounded in the narrow channel and hit a semi-submerged object. And he tried to force the crew members also not to tell the truth. Out here is the incident. You can see here. This is a true picture of the case. So the shortcut did not work out. So this was the court decision. Master has been selfish, court agrees, and extraordinary his actions have been. But still, it's related to the navigation or management of the vessel. So the owner and the charter of the Tasman Pioneer did not, endorse or acquiesce this particular action, so they were not liable because of that. And the court also went on to say that there was no evidence of barratry, that means illegal act with the intention of causing harm to the ship owner. That means you basically do wrong acts with the purpose of causing losses to the owner. It wasn't there, the court says. So the Article 4 Section 2 defense protected the owners. Although the captain made a mistake, as a result the total loss of cargo happens. The error of navigation defense, right, protected the owners of the ship. Then moving into this case, the meaning of the words play a role, phrases. Here the case was goods lost or damaged. Is it physical and economic damage included? 2023 case, Trafigura PT Limited versus TKK Shipping. Case is 2023, a very recent case. What's the story? The ship was here, the ship is here. The ship has grounded, in fact, closer to an island. Yeah, in June 2018, Toko lineage carrying 10,000 metric tons of zinc calcine. So the one who filed the case only was the owner, and the ship suffers extensive damage. And they were using the salvos. That means those who come to rescue the ships properly, they try to refloat and all. That has to be done. So more than 7% of the cargo was lost. So not all was lost, only a minute, limited percentage. More than 700 metric tons of cargo was lost. And the claimant claimed from the carrier more than 8.5 million in respect of the damages. Okay, the carrier has the duty to take care of the goods, right, under that VAR. So under that clause, section 3, right, the claimant files a case telling there was a violation by the ship, so pay me the compensation. The goods were being carried from USA to Australia, and it basically hit an atoll or ran aground, right, due to engine failure. Then it was salvaged, but still certain kind of damage has happened. So take a look at this. So the claimant said that the defendant, that means the ship owners or the ship carrier, right, have been careless in carrying out their duties. This is the true ship. Here it has run aground. So they were telling, right, they needed 8.5 million damage for claimant's liability to the salvos. That means the payments for them for the salvage work, and the physical loss and damage, shipment cost, and the cargo disposal costs. All that you have to pay. The claimant claims against the ship. But the defendant, the ship, said no. They were liable for physically damaged cargo only. Yeah, that's what they say. Okay, with us some damage was caused to the cargo, we pay for that, right? So and the liability should be kind of defined, interpreted in the wordings of Hague-Visby rule, talking about goods lost or damaged. That's it. But the claimant said what? The meaning should be this: goods lost or damaged means goods lost or damaged physically or economically. So this was the claimant's argument, that the interpretation of this wording should be changed. What did the court say about it? Yeah, Article 4, Rule 5. What does it say? Yeah, the 666.67 things in it. Yeah. Unless the nature and value of such goods have been declared by the shipper before shipment and inserted in the bill of lading, yeah. Okay, that per package, right, the maximum units that you can claim is 666.67, right? But in this case, the claimant is asking for more, much more, in fact. So what was the decision by the commercial court? Court said that the physical and economic damage has to be taken into account when constructing or when taking the meaning of goods lost or damaged. And court said, right, entire cargo was damaged and the claimant has lost the ownership to the goods, and and normally when the salvaging is done, the salvos have the right to the goods. So and they have put up a security of 8 million. So the court was agreeable to the claimant's claim of 8.5. Economic losses, yes. Take a look at transshipment, the liability to the salvos, delays. So the importance of the case is the meaning of the words goods lost to damage, right? It includes physical and economic damage. So you can claim more than 666.67 in the case of total loss of goods. So it has been a change into the current laws, right? So there the claimant could go beyond actually the amount mentioned here. But of course I think this could be taken into consideration in the case of total loss of the cargo, not loss of part of the cargo. And the next one, it's again a 2023 case, a Maersk line, a rather famous shipping carriage of goods line. Courier liability upon discharge. When the goods are discharged, what would be the courier's liability? It's about transport of cocoa beans and not collected. Was discharged in October 1st, but more than nearly 2 months, right? November 1, nearly 2 months it was not collected. And then, yes, due to the condensation and the mold damage, cocoa beans have been damaged substantially, probably a loss of a major part of the cocoa cargo, I guess. So this damage happened after the discharge was done, but before the delivery. So it's not a case of inherent vice as per the legal action. This was a case of keeping in containers for too long without being delivered. So you can't call it inherent vice. Inherent vice is the loss that can happen anyway, so this happened primarily due to the delay of the delivery. So we know about the class 5, right? Clause 5, it says that carrier is not liable for the loss or damage to the goods, right? Clearly the Hague Visby says that. And listen to what Lord Hobhouse in this particular case has stated. Discharge and delivery are distinct aspects of the international carriage of goods. While discharge is a physical operation to remove the goods from the ship, delivery is a legal concept involving a full transfer of possession of the goods by the carrier to the receiver. Discharge and delivery may therefore occur at different times. That's what he said. So discharge is releasing the goods from the ship. It's a physical act. Delivery is technically an emotional act. A more, it's beyond just physical handover of goods. It may not happen at the same day, same time. That's what the judge said. Actually, it's a lord, right? In this particular case. So what was the decision? Court said that you cannot take legal action against the ship, for it's your duty to obtain delivery of the goods. So claimant failed to claim the goods within reasonable time, so the defects of the goods did occur during that time. So there again, in that particular case, the court was less willing to put the blame on the ship. So when it comes to even today, right, the ships are fully covered under the Hague Visby rules. It's very tough to take any legal action against a carrier.